So thank you very much, everyone, for virtually coming, and welcome to this, the latest in our series of webinars from the Doughty Street Housing Team. This webinar is providing an update on the current state of affairs on possession proceedings. And it turns out by pure serendipity that we have managed to time this with the end of the sort of coronavirus pandemic provisions and the return to normal and the return of the notice periods back to the pre-pandemic levels. And it's also the day that a new Form 6A comes back in. So it turns out this has been really good timing for our webinar. I am delighted to introduce our two speakers. So we have David Carter, the font of all housing knowledge. And Jim was just reminding me that David wrote a book on local authority notices some 22 years ago. So he will be reprising that for our webinar today. And he will be followed by the ever brilliant and always interesting Jim Shepherd. Now, you will notice that you have been automatically muted when you joined this webinar. Keep your speaker on mute, but if you do have a question, there'll be plenty of time for questions and comments afterwards. Then do please share them either in the chat or in the Q&A. It doesn't matter which you prefer to use, and we will deal with those afterwards. So without further ado, I'm going to hand over now to David Carter.
Thank you, Sarah. Could we have the next slide, please? Just want to set the parameters about what I'm going to be talking of this afternoon. I'm going to be talking about notices, the first stage before possession proceedings have begun. I'm not going to be talking about notices to quit. I'm really talking about statutory notices, notices seeking possession, either in respect of a secured tenancy or an assured tenancy, and I include Section 21 notices in that. As Sarah said, yesterday new regulations came into force. The snappily entitled Coronavirus Act 2020, open brackets, residential tenancies and notices, close brackets, open brackets, amendment and suspension, close brackets, open brackets, England, close brackets, regulations 2021. The regulations came in force yesterday, and they set out new notices which take effect from today. So if you're a landlord wishing to evict your shared short-haul tenancy on Section 21 grounds, then you will have to serve a Form 6A in the form as prescribed by the latest regulations. Now, in respect of, so we're essentially going to be talking about three different notices seeking possession. Under the Housing Act 1985, it's Section 83, which imposes the requirement to serve a notice seeking possession if you're going to rely on one of the grounds for possession set out in Schedule 2. For assured tenancies, it's going to be either an assured tenancy relying on Section 8, and then one of the grounds, or an assured short-haul tenancy relying on Section 21 alone. Now, the forms are now neatly contained within these new regulations. It's important, though, to note that things have not always been quite so clear as the new regulations make them. Can we have the next slide, please? It was a bit of a nightmare for various reasons during the pandemic. And because of the government's approach, last-minutism approach to dealing with the pandemic, there have been a number of different regulations since, I think, the first changes came in May of 2020, and some of them are not entirely clear. There's an article on Nearly Legal which almost approaches a rant in discussing how bad these regulations are. But if you're acting for defendants, as I suspect most of the audience today are, you can use them to your advantage, because if you're a landlord, it is rather difficult to understand them and to make sense of them. I'm not going to go through the regulations between May and October or September the 30th, but if the chances are, if you get a client coming tomorrow, they will have been served with a notice in the last 12 months or 18 months. You will need to look at them. So really, it's just a note to ensure that you look at the regulations current at the time that the notice you're considering was served by the landlord. Anyway, the present position is that as far as the DCLG is concerned, the pandemic is over and we're back to normal, and therefore the pre-pandemic notice periods apply, albeit with new forms. Can we move on to the next slide, please? Each one of the relevant forms, so for a secure tenancy notice seeking possession, or a Section 8, Section 21 notice seeking possession for assured tenancies, the notice will be invalid unless it's in the prescribed form or to a form substantially to the same effect. Now, if I were advising a landlord, I would say always use the prescribed form. Of course, you've got to get the right prescribed form, bearing in mind what I said a moment ago. But the words or to a form, actually, or in a form substantially to the same effect, that does give landlords a degree of latitude in which a notice which doesn't precisely follow the prescribed form may nevertheless be valid. There is some guidance from the courts on this, because these words have existed since secure tenancies came in the 1980 Act. They haven't really changed. They haven't changed at all since then. Some of the cases are quite old. The one mentioned on the screen is Ravenseth Properties and Hall decision, now nearly 20 years old. In that case, the question was whether a Section 20 notice was substantially to the same effect, and the court allowed the well, first of all said it was a question of factual degree, so you have to look at all the circumstances in deciding whether it's substantially to the same effect. That includes the knowledge of the tenant as well as the knowledge of the landlord. And indeed, in subsequent earlier cases, that's mentioned in the note below, Devlin, Stidolf, and Islington and Dyer, the court has said that you are entitled, the court is entitled to look at accompanying documents to decide whether it is substantially to the same effect. And so, for instance, let us say that there is a notice of possession is served in the old form 6A, and there have been, I think, now 3 different versions of 6A. And 6A starts off with various statements giving advice to the tenant. But let's say if some of that is missing, but there's an accompanying letter which explains it, then it is likely that that is going to be to perform substantially to the same effect. Next slide, please. Now, this is aside from the question of whether it's the prescribed form. The notices will nevertheless be valid if the error on the notice is obvious. And there have been a large number of cases on this, but they date back to a House of Lords decision called Manai Investment against Eagleston Life Assurance, in which Lord Hoffman, I think it was, waxed lyrical about what a notice meant. And he talked about what difference would it make if a notice was on blue paper when it was pink paper was ordained by statute, somewhat fancifully. But what the conclusion that he came to and the other law lords agreed with was that an error on the face of the notice does not invalidate it, provided the recipient of the notice understands it and the notice is sufficiently clear and unambiguous to leave him or her in no reasonable doubt about what the effect of the notice was. Now, this concerned a business tenancy. I think it was a Section 26 Landlord and Tenant Act notice, and a key date was wrongly stated. I think it was a year out. And the court decided that having regard to the knowledge of the recipient, the tenant, and the surrounding documents, it was entirely clear that the notice was what was intended to take effect. Now, Manai is still good law. It's been relied on by the Court of Appeal in a number of cases. Some of them I've mentioned in the next bullet point. The most recent is a case called Pease and Carter, decided last year. And in that case, the tenants, so joint tenants, Mr. and Mrs. Carter, were served by the landlord with a Section 8 notice. The notice stated that court proceedings would not be started until after a particular date. And the landlord was alleging rent arrears, relying on grounds 8, 10, and 11. It went at the first hearing, a district judge held the notice was defective because the date given was wrong. It was it didn't give the requisite period of notice. But nevertheless, he made a possession order because he allowed the landlord to amend the notice. The tenants then appealed to the circuit judge, who quite rightly held that you couldn't amend the notice under Section 21. It then went to the Court of Appeal, and the Court of Appeal said, well, you may not be able to amend it, but it's quite clear to Mr. and Mrs. Carter what the landlord was saying. And despite the defective date, having regard to the circumstances, they had the requisite notice. Next slide, please. This relates to the next topic to consider is whether it has to be serviced by the landlord of the notice or whether it can be by an agent. And there are two cases, Prempeh and Lakhani, where notice was given by the landlord solicitor. A solicitor had served the notice and signed it. Court upheld. The court decided that was valid. You could give it by notice, and then that's the most recent of these cases. They relied on, in that case, the landlord relied on City of London and Devlin, and there's two citations, paragraphs 49 and 50, in which the court held that there was no requirement that the form 3, had to have the landlord's own name and address, and an agent's name could be used. So if an agent serves it, that's good enough. Next slide, please. That brings me on to the next point. What about corporate landlords? Well, many landlords are corporate landlords in the sense that they're a company, usually a limited company, limited by shares. Companies Act provides that if a company wishes to execute a document, it can do it either by affixing its common seal or by signature in accordance with the following provisions of Section 44, and they set out there have to be two directors, or the secretary and the director. The question is, what happens if a director on his own or an employee of the company signs the notice? Is that good enough? because if it's a document to be executed, then it would clearly be invalid. In Northwood Solihull Limited against Fern, the court said it didn't need to be executed in accordance with the Companies Act because a notice could be given by an agent, and therefore an individual director could be an agent of a company, or a duly authorised employee of the company could act as an agent. So no point has been taken on that. There are other circumstances in which you can take a point on the Companies Act. For instance, where a company seeks to take possession proceedings in its own name without representation by a solicitor, then that would require proper execution. And equally, I think for a tenancy deposit certificate is a document which has to be executed by the company. Next slide, please. Right, waiving and amending notices. Well, I alluded to this point in describing Pease and Carter. The general position is that the court has the power to waive or allow an amendment of Section 83 notices for secure tenancies and Section 8 notices for assured tenancies. That's the general rule, but there are exceptions. And should I say this, the power to waive or amend is on the court being satisfied it's just and equitable to do so. It's a pretty broad phrase, which entitles the court to look at all the particular circumstances of the case. Anyway, the exceptions are that a Section 8 notice cannot be amended or waived where the landlord's relying on 3 of the mandatory grounds. And I've missed one out in the slide, 7A, 7B, and 8. So 7A and 7B are sort of antisocial behaviour grounds. Ground 8 is, of course, the mandatory ground for rent arrears. So if, for instance, a landlord's relying on ground 8, say 2 months rent arrears at the date of the service of the notice seeking possession, and 2 months rent arrears at the date of the first hearing, then there is no power to amend that notice. Equally with ground 7A and 7B. There's no power to amend a Section 21 notice, as was apparent. Section 18 P's, wasn't it? But there is no power under Section 21 to amend that notice. And then finally, in relation to secure tenancies, one of the newer grounds, the absolute ground for possession for antisocial behaviour, which is Section 84A, there is no power to amend a notice relying on that ground under 83ZA. But if, for instance, you are claiming that relying on ground 2 of Housing Act 1985, so nuisance or annoyance to neighbours, then that is capable of being waived or amended by the court. But again, the court has to be satisfied it's just and equitable to do so. Next slide, please. Deregulation Act 2015 introduced a number of changes, making it harder for landlords to gain possession of Section 21. One of them was the introduction of Sections 21, subsection 4B and 4C. So this is to ensure that a landlord cannot start possession proceedings until at least 4 months into the commencement of the tenancy. And it talks about original tenancy and replacement tenancies. Those are defined in Section 21 4B. The original tenancy is a tenancy which is not a replacement tenancy. Is, as the name suggests, the first tenancy. A replacement tenancy is one which has, maybe there's a series of tenancies, and the replacement tenancy is one that is not the original. You may have several if there's a string of tenancies. Next slide, please. Deregulation Act also introduced prescribed requirements. And our prescribed requirements fall into two categories. First, the landlord has got to serve the tenant with an energy performance certificate free of charge, and if gas is supplied to the premises which are let, a gas safety certificate. And until that has been done, the landlord cannot give a valid Section 21 notice. Again, this is always something worth checking because it's frequently omitted. However, the effect of it has been certainly diluted by two fairly recent cases. First is Minister and Hathaway decided in the summer of this year. The landlord, in that case, the landlord had initially let the premises in 2008, and there had been and the tenant had occupied continuously since that date under a series of short-term tenancy agreements. So when the new provision, Section 21A, requiring the provision compliance with prescribed requirements came into force on 1st October 2015, the tenant was already in situ as an assured short-term tenant. He was not subsequently served with an energy performance certificate. And the defendant argued successfully before the district judge that the landlord should have served him with an EPC before taking possession proceedings. The landlord's appeal was allowed by the circuit judge. The tenant then appealed to the Court of Appeal, and the Court of Appeal upheld the circuit judge's decision. And so the provisions relating to EPC and equally gas safety certificates only apply in respect of tenancies which have been created, original tenancies created after October the 1st, 2015. And the second case, which I think is probably well known, Carroll House against Rounsfield, the argument there was that the gas safety certificate had to be served at the time the tenancy was into, and the Court of Appeal said no, as long as it's been served at any point before the Section 21 notice has been served, then it is valid. Next slide, please. The prescribed requirements not to be confused with prescribed information, which is another amendment introduced by the Deregulation Act. Landlords have to give the tenant a document, which is called How to Rent the Checking for Renting in England. And this must be served before the issue of a Section 21 notice. It does not need to be served at the when the tenancy is entered into, but it must be served prior to the Section 21 notice being given. And the version that must be served is the current version. It has, since this provision came in October 2015, there have been a number of different versions of the How to Rent booklet. It's constantly being updated. You can download it from the DCLG website. But again, it is worth checking that the landlord has served it at all, and if he or she has served it, that it was the version current at the time of the service of the notice seeking possession. It's not entirely clear whether a landlord who has served this at the start of the tenancy, but then there is a new version which comes out before serving the notice seeking possession, Section 21 notice, whether the landlord has to serve another one. I have to say, to be on the safe side, landlords should do that, and that may be a point worth taking in a defence. Next slide, please. Tenancy deposits. Well, this is a minefield for landlords, and I have to say, I don't think I've ever seen a deposit case where there hasn't been a way to defend on this basis. Essentially, the three requirements seem fairly simple. The deposit has to be held in accordance with an authorised scheme, but the initial requirements of the authorised scheme must be complied with, and the tenant must have been given the prescribed information within 30 days of the deposit being received by the landlord. Now, there is no prescribed form, but prescribed information is set out in a statutory instrument. And it really is well worth going through it if you're acting for a tenant, and ticking off the various paragraphs to see if they've been complied with. Chances are you'll find something wrong with it. Many landlords think it is sufficient, for instance, just to serve a deposit protection certificate. Far from it. There's a lot more to it than that. So this is not a webinar about tenancy deposits, but I just flag it up because if the landlord is in breach of any of those requirements, then the notice is invalid. Next slide, please. There is a recent case decided in the last couple of months where the Croydon against Colunga, this is a secure tenancy. Croydon, like many London local authorities, grants fixed term, the so-called flexible tenancies to their tenants. This was a fixed term tenancy. Mrs. Colunga fell into rent arrears. Croydon served a notice seeking possession based on ground one arrears. And she defended on a very sort of old-fashioned basis, and that is that it was a fixed-term tenancy, and there was no forfeiture clause. And as anyone knows who's done first-year landlord and tenant, if you've got a fixed-term tenancy, the only way it can be brought to an end is by forfeiting the tenants, by forfeiture. And in this case, Croydon had not included a forfeiture clause, and the Court of Appeal said in those circumstances, the tenancy will go on for the 5 years, regardless of whether she pays rent or not. They have, however, granted Croydon permission to appeal to the Supreme Court, and we will await that judgment in due time. Next slide, please. Lastly, this is the last slide. Service from the public trustee. If a tenant dies, then if an assured or a secure tenant dies, then somewhat self-evidently they are not occupying the property as their only or principal home because they are dead. So a notice seeking possession is not the document to serve because they've ceased to be secure or assured. And the procedure to be adopted is to serve a notice to quit on the premises and a copy on the public trustee. And in Gateway, they did serve a proper notice to quit, giving the right period of notice with a saving clause so that it took effect on the due date. But they didn't serve on the public trustee at the same time. And the public trustee, therefore, was not given the requisite period of notice. And the tenant's argument, well, sorry, not the tenant's argument, the personal representative of the tenant's argument was that that notice on the public trustee had to be capable of determining the tenancy. Therefore, that the requisite notice had to be given. The Court of Appeal rejected that argument, said it's sufficient that notice is served on the premises, provided that's valid. Then you have to serve a copy on the public trustee. The fact that the public trustee didn't receive it until a bit later, so that the period was not adequate, is irrelevant. I think that's the end of my talk. I think it's now over to Jim.
Thanks, David. I'll just wait for my slides to come through. Hopefully everyone can hear me. Welcome everyone, and I hope you're having a good afternoon. This is definitely a graveyard slot because I am, last thing on a Friday afternoon. I hope you're listening to this in comfort, as I normally do, listening to webinars, lying down and occasionally drifting into sleep and then coming back again. But hopefully I'll be able to keep you awake. The next bit of the talk really is about what comes after the notices and the possession claim itself. And I'm saying, where are we going and are we taking sandwiches? And the answer is, I don't really know, but I can speculate. And I think there's going to be disarray, whatever's happening. But one thing that hasn't happened, which I'm quite surprised about, is there hasn't been the predicted, mainly by me, the predicted tsunami of possession cases. And I think that's because the court system have quite neatly kicked things into the long grass and delayed things, and we'll come on to that. But first of all, the interim period under Practice Direction 55C is still in place, and that doesn't end until the 30th of November. So this part of the talk is only really valid for 2 months. But the courts are still dealing with stayed claims brought before the 19th of September 2020, and they're working through cases according to the Master of Rolls list of priorities. Generally, if tenants have been very naughty, then their cases are going to come up quickly, or if their arrears are large, then their case is going to come up, or if there's been fraud and that type of thing. So that's, you can check out the Master of the Rolls list of priorities for the cases and determine whether your court are actually acting in accordance with it. But still, reactivation notices are required in cases before the 3rd of August 2020. You'll probably all know this, but just as a way of reminder, really, in the new and stayed claims post 3rd of August 2020, there's still an opportunity to challenge if a social landlord, for instance, has not complied with the pre-action protocol for social landlords. And you'll note from the practice direction that it is obligatory. It doesn't say may, it says must. So it seems to me that if they haven't complied, then the possession claim must go. Equally obligatory is the requirement on all claims to give details of the effect on the defendant of coronavirus and the requirement of the landlord to serve notice on the tenant. Again, the word used in the practice direction is must, which shows that it's an obligatory requirement. I've certainly seen cases where it hasn't been carried out. Finally, in relation to things that may be challenged currently, it's always worth checking that the overall arrangements have been followed. If there's no review date, there is no valid possession claim. They've got to go through the sequence of events according to the practice direction and the overall requirement. Otherwise, it's not a valid claim. Next slide, please, right? So what about the business end, which is really the make or break for tenants' evictions? Well, we know now that the ban's been lifted, and that was lifted on the 31st of May 2021. There has been a level of chaos, which we expected, really. There is now, however, a mandatory 14-day notice period before the bailiffs or High Court enforcement officers can execute a possession warrant. So first of all, you need to check that that notice has been given to your client. But as was pointed out, I think in the LAG magazine, that didn't account for the fact that if an eviction failed and a new date was required and needed to be fixed, then what happens? And this was highlighted really by the ministerial letter to the Chair of the Housing Communities and Chair of Housing and Communities and Local Government, where it was said that where an eviction is scheduled, this will not be carried out by the bailiffs if they are made aware that the tenant or anyone they live with has coronavirus symptoms, has tested positive for COVID-19, are waiting for a test result, or has been instructed by the NHS to self-isolate. It's understood that that's led to numerous failed evictions, because there's a lot of people with coronavirus or suspected coronavirus at the moment. So with effect from the 7th of August 2021, an amendment was made to CPR 83.8A2 to provide a requirement for a further minimum 7 days written notice of eviction if you have one of these stalled evictions. So that, again, you'd have to check that that's actually been done. My colleague in Chambers, Marie Paris, recently tweeted a message which was picked up by Nearly Legal, saying, my client applied to suspend a warrant yesterday afternoon and told his bailiffs that he had COVID symptoms and was waiting for his test results. The bailiffs proceeded to do a lateral flow test this morning and evicted him before the application could be heard. And she said, dangerous on many levels. Absolutely. And I think that eviction was set aside. So if we could have the next slide, please, right. Government guidance. The government guidance on all of this, on possession claims, etc., is definitely worth reading for two reasons. First of all, you may be able to use it if it hasn't been followed. It's non-statutory, but you still may be able to use it in an application or in defending a possession claim if there's been a failure to follow that guidance. Secondly, it's really helpful. I found it helpful anyway, in an increasingly complicated world. And I think everybody in housing needs to be congratulated for the way that we've dealt with the coronavirus crisis, really, because not only are we having to deal with an area of law that has about 26 different statutes involved, unlike planning law that only has one, but also we are having to deal with this crisis and the repeated changes that have been taking place with different practice directions, etc., notices, as David's just said. So it really is a very helpful source, this guidance, and I would urge you to have a look at it if you need to, in order to assist you to get through all of this. Next slide, please, Ryan. So case law. I'm going to go through some of the recent case law I've found interesting and informative, and hopefully you will too. The first lot of, or couple of cases are about the thing called guardians. They're a personal bugbear for me. I've actually been involved in one or two cases involving guardians, and it's basically a cheap way for property developers to keep their empty properties or the buildings of others free of squatters and vandalism. And they allow people to occupy rooms, often in office buildings, for a period of time, paying a rent, to all intents and purposes having exclusive possession. Well, that looks like a tenancy to me. I'm old enough to remember the importance of Street and Mountford and the clear distinction that was made between tenancies and licenses, and the reference to sham agreements. Well, without generalising, and I'm going to generalise, a lot of these guardian agreements are precisely that, sham agreements. And if Lord Templeman was still alive, and he gave the leading judgment in Street and Mountford, I'm sure he'd agree with me. These sham agreements and the guardian arrangements need to be dealt with, in my opinion, once and for all by the Supreme Court. And I think there's a number of cases going in that direction, because, in my view, they are cutting holes in the security of tenure as we know and love it. The first hole cut was the case of Camelot Guardian Management Limited, and that was a little while ago in 2018. And that in that case, the High Court found that even though Mr. Koo, the tenant, had exclusive possession, there was a license in place. And it seemed like all the ingredients for a tenancy were there, but notwithstanding that, they found that there was a license there. And then more recently, the case of Global 100 Limited by, I won't try and pronounce the name of the tenant, but it was a decision of His Honour Judge Luber on appeal. And this was another Guardian case, which was also important in relation to CPR 55.8. If you remember, CPR 55.8 is basically the provision where the judge determines if there's a sufficient dispute to go to trial, and whether the case management directions should be given, or whether it should just be given short shift. And remarkably, one of these Guardian cases was given short shift, and I find it impossible to understand. But I hope District Judge Parker isn't watching. But it was decided that in that case that the grounds of dispute were not substantial. And it seems to me, if there's any argument potentially that there's a tenancy rather than a license, then those are substantial grounds. And unsurprisingly, the case was appealed to His Honour Judge Luber. And basically, there were three heads of defence before the district judge when the possession order was made. First of all, it was said that the landlord did not have sufficient interest. Well, we don't need to worry about that. But just for your information, this was a building owned by the NHS, and they entered into a property guardian management agreement, whatever that is, with Global 100. And it was found that they basically, His Honour Judge Luber found that they did have sufficient interest, basically on the basis of a contractual agreement. And those of you who remember a case of Baxter and Camden would remember that. But there was also an argument in relation to incorrect service, and that was also given short shift by His Honour Judge Luber. But the argument that really resonated was the central one, which was about whether this was a tenancy or a license, and whether the agreement was a sham. And thankfully, His Honour Judge Luber felt that the judge should not have booted that out and should have given directions in relation to a trial of that issue. But he also gave some quite good guidance in relation to CPR 55.8. He said, just to quote a bit of it, in my judgment, the threshold in CPR 55.8 must be a relatively low one. He followed the guidance in a case called Birmingham and Stevenson, Lord Justice Lewison. And he essentially said the decision whether to adjourn a hearing or not is preeminently a matter of judicial case management. But the specific inclusion of the features identified in CPR 55.8 strongly suggests that if the claim before a judge has been disputed on grounds which appear to the judge to be substantial, then case management direction should be given. So in relation to the license versus tenancy point, the judge, as I say, allowed the appeal in relation to that. And he essentially said that, in this area, in Guardian cases where at the moment uncertainty reigns, any judge should give case management directions if a defence is raised. He said, in the present case, the terms of the licence agreement entered into by Ms. Laliva may have been similar or perhaps even identical to those of the Camelot case, which is the one I referred to, Camelot versus Koo. But that did not foreclose her from contending that in the circumstances of her particular occupancy, she actually enjoyed a tenancy, and that the licence agreement either innocently mislabelled the relationship or was a sham. And then he looked at the fact that there was a number of these Guardian cases working their way through the court system. He said, both counsel were right to draw my attention to the fact that other claims brought on a similar basis by the same claimant are awaiting trial on the same lease license sham points in this court. Likewise, that property guardianship is a relatively novel concept in our law of property, and its implications are still being worked through by the courts. And that was enough to suggest that, you know, there were substantial grounds for defending the claim. So at least in relation to the tenancy license point, that was good news, because the appeal was allowed on that basis. Another personal bugbear for me, and I'm sure for a lot of people defending possession cases for vulnerable tenants particularly, are mandatory possession claims. And it seems to me that there are few and far between. The victories in these cases are few and far between. But there's a little case in Wales which is quite informative. And basically, I think the lesson that we have to learn is that you have to look very carefully. I mean, this probably could have come in within David's talk, but I slipped it into mine. You need to look very carefully at the notices in these mandatory possession claims, because there's often a defence hidden away somewhere, and it's they're very difficult to get right, a bit like Section 21 notices. But as I say, there's this useful case in Wales against Pembrokeshire County Council, which in Wales is the posh council. And basically, Mr. Hambrook was a secure tenant, and following complaints of noise nuisance, Pembrokeshire brought a claim for possession, relying on a conviction of breaching a noise abatement notice. So they relied on the mandatory ground. They served him with a notice, but the defence team there were able to identify that the notice did not inform Mr. Hambrook of the time within which the request for a review must be made. So that is mandatory, and it hadn't been done. It also stated that the proceedings could start immediately. Of course, they couldn't, and that the tenant must give up possession within 28 days of the notice. At first instance, the District Judge Pratt, gave Pembrokeshire permission to amend their claim to rely on the mandatory ground for possession. And that approach was given very short shift by His Honour Judge Beard, who basically said, you know, you've got to get your notice right or not in a mandatory ground case, which is absolutely right, and struck out the possession claim. So it's good. It's only a first, circuit judge decision, but it's very important to look at these notices closely and determine whether, that there is any holes in them. If we could have the next slide, please, Ryan. So the next area is succession, which is a bit painful for me at the moment because I just lost the case yesterday, and they're very, very difficult to win. Anyway, this case that I want to refer to, Tower Hamlets and Alley, it's at least a successful non-statutory succession case, of which there are not many. In that case, Mr. Alley's mother was a secure tenant. She'd acquired her tenancy by succession. After she died, Mr. Alley applied to Tower Hamlets under their discretionary succession policy. Unsurprisingly, which seems to be the default really for discretionary succession applications, the local authority decided that Mr. Alley had not resided at the property and therefore just brought a claim for possession against him. And the claim was defended on public law grounds. I'm sure we've all done this. And basically the argument was the decision was flawed because it failed to consider all of the evidence before it. And District Judge Naidu dismissed the claim for possession and said it was apparent from the evidence of the housing officer that Tower Hamlets was unaware of and therefore had not considered the evidence submitted by Mr. Ali, which demonstrated that he'd resided at the property. It's fairly basic, but you have to, if you have a policy, then you can be expected to properly apply it. And Tower Hamlets hadn't done that. They'd adopted the default position, which is you're not entitled. Section 21, actually, I'm not going to talk about Minister and Hathaway because I just noticed that David talked about that. But as a way of part 2 to the Kalonga saga, which was the fixed term tenancy that David was talking about, which I think is a brilliant case. And it was actually highlighted by a former colleague of mine, Andrew Diamond, in an article a long time ago before flexible tenancies came into force, that the forfeiture, if tenancies did not have a forfeiture clause, then people would be stuck with with tenants for a lot longer than they thought, and that has come to fruition. And we'll obviously see what the Supreme Court say about Kalonga, but in the meantime, Miss Kalonga's fixed term has ended. And so Croydon served notice under section 107D3 saying they weren't going to renew the term. Surprise, surprise. After she's in the Supreme Court against them. Anyway, that was challenged by her because what happened was that section 107E1 of the Housing Act 1985 provides that a review of a decision to not renew a fixed term tenancy must be made before the end of the period of 21 days, beginning with the date on which the notice under section 107D3 is served. So once the local authority serves the notice saying we're not going to renew your tenancy, you have to challenge that within 21 days. But unfortunately for Miss Kalonga, she didn't discover the notice until the 9th of May. And so sought a review request out of time. Unfortunately, the 21-day period expired before she sought her request. And she asked them, as I say, to exercise discretion, to ask Croydon to exercise discretion to accept the review request out of time. Unsurprisingly, again, Croydon said no and said it had no power to do that. And actually, the High Court held that there was no power to accept an out-of-time review request. And that was comparing various different statutory provisions that did have the ability to extend time against this one, which apparently doesn't. But the High Court were clearly a little bit jittery about the whole thing because they granted Ms. Kalonga permission to appeal on the basis that the appeal may have real prospects of success. So that's turning into, I think the Kalonga saga is turning into a bit of a Jarndyce and Jarndyce. It's quite interesting to think, well, does the fact that the period, that her tenancy period has now run out, make the application to the Supreme Court odious? I don't know. We'll have to see what the Court of Appeal say about the second matter. Anyway, that is, I think, my lot. Hopefully it's been of some use. The end.
Thank you very much. Thank you very much, David, and thank you very much, Jim. I can't see any questions, so perhaps that means I'll give it a little moment to see if any questions come through. But hopefully that means that Jim and David were completely clear, and now you know everything that we need to know about possession proceedings and the current situation. So we are always available by email if you've got any questions, if it suddenly occurs to you that you've got this burning question about something that one of our speakers were talking about, then do please drop us a line and we'll do the very best that we can to help. We've got another webinar coming up, but I'm afraid I've been trying to find out what day it was on, but I can't bring it to mind. But we have Donna Green and Marie Paris and Alice Irving all speaking at an upcoming webinar on antisocial behaviour. I think it's on the 14th of this month, I'm being told. So that should be something to look forward to, something that comes up all the time that we don't often give perhaps the attention that it deserves to those issues. We're also hoping to have another webinar coming up on how to determine questions of mental capacity in housing proceedings. So hopefully you will join us on the 14th and for upcoming webinars, and we will see you all soon. Thank you.